But that's okay, right? Because they're our children, and that's where they're mamas. I didn't want the house. I literally wanted nothing but my daughter. That was the only thing that was important to me. And I think that really showed the court that I was just being honest, because I don't care about anything else. Hey mamas, Kathleen here. I wanted to discuss today divorce and custody rules for women, some mistakes I made, and things you can do to avoid hopefully making those mistakes. Quick reminder that I'm not giving legal advice. I'm not a lawyer or a solicitor, but I'm here to share my story and some tips and some resources that will hopefully help you in the future and help you mamas get through this. Rule number 1, get an attorney with at least 10 years experience in family law. But as a caveat to that, you also want a lawyer that is passionate about family law. So one of the mistakes that I made, one of the many mistakes I made, was I chose a lawyer. He was in family law practice. However, he was more passionate about criminal law, and I did not know that. So he passed me off to a very green lawyer within his practice, and it didn't work out very well for me. But, however, due to my documentation and advocating for myself, this is what really saved me in the end. And if it weren't for this, my advocating for myself and my very clear documentation, I would not have received primary custody. Number 2, mamas, file for divorce before your husband does. This will give the court a chance to hear your side of the story and will allow a little bit of steering for your direction for the trial. That doesn't mean that the court will decide in your favor. However, if you do take the initiative to get the divorce, that can also show that you provided like this leadership role, if you will. That way, the court can see that you said, we're going to stop this before this relationship turns more sour. Additionally, so your husband's side, you will hopefully have all of your documentation in a row or what you need at that time, and then they'll have to likely play catch up. Number 3, do not waste time having a chat with your attorney because it will cost you money. So anytime that you call your attorney, you send an email, anytime they spend any time on your case, it will cost you a small fortune. So make sure it is, anything you talk about, it is pertinent information. The things that the court will likely be interested in, and I made this mistake, I thought something was important. Please do keep that for your documentation. You do need all of that for your documentation because you don't know what will be important or pertinent now and then pertinent later. So the things the court does care about is physical abuse, child endangerment, financial statements, child support, and any debts. Make sure you have a list of questions for your lawyer before you call them, because if you're scrambling in your brain and it's not coming out correctly, you're also billed for that time as well. So God bless you, Clifford. That's my dog. But these are really important things that so it doesn't cost you an arm and a leg, because it'll already cost you a small fortune. But is it worth it? Yes. Yes, it's absolutely worth it. The debt is worth it because the custody of your child lasts until they're 18, and then for the rest of their lives. It impacts them for the rest of their lives. So it is important. Okay, number 4, documentation. Make sure you document like your life depends on it, because it does, or your child or your children's life depend on it. So if you want primary custody of your child and then you want a successful divorce settlement, my main thing was custody of my child, then you must keep extremely detailed records. I did this with screenshots of text messages and later emails, but primary text messages, which were such a pain. So I recommend, especially if you have anything financial, not to use text messages because it's just a disaster. It's a complete disaster trying to take screenshots. We had to take screenshots because my ex had used this platform, which is great for confidentiality, but you had to take screenshots. You couldn't get a PDF. So that was horrendous for time's sake. But our Family Wizard is great for documentation. My co-parent or my ex still refuses, so hopefully at some point he will agree to that. But I would email anything pertinent to your ex regarding explanation of benefits, regarding anything medical-wise, receipts, upcoming appointments. I've ended up going to email recently because texting has just been a fiasco. But also, depending on your state, your nation, wherever you reside at in the world, if you are in a state or an area that allows you to record, this is extremely important. So in the state of Wyoming, where I currently reside, they allow a one-party consent. So if it were myself and my ex-husband, I would be the consenting party. He doesn't have to consent to me recording. So in any case, if he were to try and be physical or verbally aggressive towards me, that could be used in court. And that can be used in court for you as well. And I'm so sorry if they do not allow you to use that in your state. Maybe there is recordings on your car that would be admissible in court. So keep those things in mind. If you have something that is in your car for insurance purposes, that would be amazing. That records, let's say, how you drive or other drivers around you. That could possibly help you and be beneficial as well. But make sure that you document the heck out of everything. That way, I know that I have gone through my messages or even just a quick photo and said, oh, I didn't think that was going to be important, but it ended up being important later on. So don't delete anything, just keep record, keep it in by months, whatever works for you, and you could do this. It's going to be okay. Number 5, stay cordial and professional. I know this is very difficult most of the time because the likelihood of you getting along with your ex or soon-to-be ex in a amazing manner generally doesn't happen. But if that is your case, that is great. But still maintain some decorum. Okay, so make sure that any text messages, any emails, any communication at all, recordings, if that is the case in your area, make sure that it is in a professional light and that shows you in a way that's able to communicate and be really just co-parenting for your child and just child focused. And always use some sort of discretion before you say anything nasty or deplorable. You do not want that at all because that will be used against you in the future. So yeah, just like we had talked about before, you want to be the one in the positive light. Just make sure that anything you say, the other side can use against you as well. So take some time before you want to send that message. Step out of the room, go outside, do something for yourself, do some deep breathing. And there are plenty of platforms out there that can help you rearrange your language so it doesn't appear so hostile, right? So our family wizard has a tone meter, which is brilliant. You can also type something into ChatGPT, whatever message you're wanting to send, and then say, make this sound professional, and then put your statement in. Those are great free platforms, or ChatGPT is a free platform. Our Family Wizard is great for all documentation, but these are things that will help if you're having a really hard time not wanting or just trying to stay professional, but you're just really emotional. And that's okay. It's okay to be emotional because it's an emotional time. And it's our children. So you're allowed to have your feelings. Just don't let all of your feelings pour out into your messages, because that doesn't look good. And I'm sorry about that. Just take your time to have your feelings, and then, try and send your message in a professional way. So just again, remember, every interaction will be seen in court. Stay cordial and professional. So everything in between the time you decide that you're going to have the divorce or be separated, and until court, that will all be used, or could be used in your favor or against you. So make sure that you look like the better, more level-headed parent. Number 6, initial court orders are likely to be similar to your final decree. So in divorce and custody cases, you have an initial meeting with the judge to discuss preliminary reasons for divorce, and this is set before your actual trial. And that is generally, depending on where you're at and how backed up your court system is, wherever you're located in your area, is 3 to 10 months, give or take. So at this point, it is so crucial that between that time moving forward, that you are proving to be the better parent to take care of your child. In my case, I had been, and I continue to be, the only parent who took my child to doctor's visits, dental appointments, any appointments in general. I knew, that's my dog. I knew all of my child's medical professionals' names. My ex did not. I paid all the bills. My ex did not. But proving that you are the better parent by taking care of your child. If you are not, if you're not a current working mom and you stayed at home, your situation might be a little different, and that's okay. But the temporary decree that the judge writes is very similar to the final decree, but that doesn't mean that what you say and do right now doesn't matter. What you say and do is so crucial at this time. And this decree, essentially, like, you have to follow this for the rest of your child's life until they're 18. So it's really important. And as much as you can't stand the other parent at this time, it's really important to maintain some decorum and just be cordial and be child focused. Just focus on the child. If anything takes a downhill turn in texting or communication, just try and stay child focused. Number 7, stay truthful and speak from your heart. Judges are not in the court. They're not stupid. They will know, likely know if you're telling the truth. Do not make up stories about your ex. And if you are caught in a lie, it will be held against you, and not in your favor. Allow yourself to be emotional at your trial. Allow yourself to be emotional, not all the time, but there is a time and a place. For instance, at my trial, I did become very emotional because my daughter is the most important thing to me. But that's okay, right? Because there are children, and that's where they're mamas, you know? But the most important thing, and I let the court know, is I did not want anything monetarily wise. I didn't want the house. I literally wanted nothing but my daughter. That was the only thing that was important to me. And I think that really showed the court that I was just being honest, because I don't care about anything else. I said that I wanted my husband to keep everything. I just wanted my daughter, and I ended up with primary custody of my daughter, which generally doesn't happen in our area or very much anymore, which really was, and there's other things too. That wasn't the only reason. There are so many other factors there that I provided very clear documentation on. But there was very clear reasons why I was a better fit for a primary care provider for our daughter. So stay truthful, speak from the heart, and don't make anything up. Just be honest. The next video coming up, I'm talking about my beginnings going through divorce and custody, and hopefully you can be successful like I was. If you found the information in this video valuable, I created a community for mamas just like you. It includes resources, a ton of resources, and weekly Zoom calls. So hopefully you can be successful like I was with my daughter in my custody and divorce case. Please click the link below for more information if you're interested. And thank you so much. And you've got this, mamas.